on Oversight and the Subcommittee on Research and Technology will come to order. Without objection, the Chair is authorized to declare recess of the Subcommittee at any time. Good morning. Welcome to today's hearing entitled National Security Foundation's Oversight of the NEON Project and Other Major Research Facilities Developed Under Cooperative Agreements. Without objection, the Chair authorizes the participation of Ranking Member Johnson, Ms. Bonamici, Mr. Grayson, Mr. Barra, Ms. Esty, Ms. Clark, and Mr. Byer for today's hearing. In front of you are packets containing the written testimony, biographies, and truth in testimony disclosures for today's witnesses. I recognize myself for 5 minutes for an opening statement. Good morning. First, I want to thank our witnesses for being here today. I'm looking forward to hearing from each of you on this very important matter. We are here today to discuss the National Science Foundation's oversight of the National Ecological Observatory Network, also known as the NEON Project, and other major research facilities developed under cooperative agreements. The NSF funds a variety of large research projects, including multi-user research facilities, tools for research and education, and distributed instrumentation networks. In December, the House Science, Space, and Technology Committee held a hearing regarding one of these large research projects, the NEON Project, after learning about the mismanagement of appropriated funds. Specifically, the hearing discussed the findings of 2 financial audits of NEON conducted by the National Science Foundation's Office of Inspector General and the Defense Contract Audit Agency. One of these audits discovered that NEON was allowed to use federal money for explicitly unallowable costs, including liquor, lobbying, and a lavish holiday party. Both audits of the NEON Project were initiated by the NSF Office of Inspector General due to concerns about the lack of NSF's review of cost and accounting financial controls of major research facilities prior to entering into cooperative agreements. In fact, during its first audit in 2011, DCAA had to suspend its audit temporarily as the information supplied by NEON was inadequate to complete the necessary financial analysis. Of the proposed $433.72 million project cost, DCAA identified approximately $102 million of these costs as questionable and identified an additional $52 million of the proposed cost as unsupportable. The final version of the first DCAA audit was transmitted to the National Science Foundation in 2012, accompanied by an NSF Office of Inspector General written alert about the excessive cost and accounting deficiencies for major research facilities. A second audit of the NEON Project, which was completed in October of 2014, revealed that NSF approved management fees, which included paying $375,000 for lobbying, $25,000 for a holiday party, and $11,000 a year for coffee services. In addition, according to an October 2014 National Science Foundation letter to Senators Grassley and Paul, NEON isn't the only cooperative agreement receiving such fees. If one project can get away with this, how do we know they aren't all frivolously spending hard-earned taxpayer dollars? As a small business owner and a former director of a nonprofit, I wholeheartedly understand the importance of accountability. The fact that a nonprofit can treat American taxpayer dollars as profit without any kind of consequence is absolutely inexcusable. What is even more inexcusable is that NSF has received warnings about this kind of irresponsible spending over the past 4 years and has not taken adequate measures to resolve the matter. I am not only interested in learning about how the federal government can and needs to do a better job with transparency and accountability, but also how we can ensure that this kind of negligence is not occurring with other cooperative agreements. Taxpayer money should be spent in a responsible way and with the help of efficient management and oversight. If there are loopholes out there allowing this type of unethical spending to occur, then we need to get down to the bottom of it and make sure that it can no longer happen. I look forward to today's hearing, which I anticipate will inform us on how these types of questionable expenses were charged to the American people. In the end, though, I hope that this hearing will inform us on how to provide better oversight and management of federally funded research projects to ensure that taxpayers can trust us with their money and know that it will be spent in the manner intended. I now recognize the ranking member, the gentlelady from Texas, for an opening statement.
Thank you, Mr. Chairman. Before I begin my formal statement, I simply want to say that as of this morning, we have 2 additional members assigned to this committee, so we'll be able to organize later this week, and we will be ready to act as subcommittees. Let me thank you, and I want to start by saying that I join all of my colleagues in expressing my dismay that Neon used its management fee to pay for lobbying and alcohol and employee morale. I think we can all agree that we cannot support these actions. I also want to recognize NSF and Neon for adopting reasonable limits on what their management fee can be spent on going forward. There's no doubt that some of my colleagues see advantage in the negative headlines that have come with Neon's story because they can point to those confused claims as evidence that NSF is not a careful steward of taxpayers' dollars. This situation might even be viewed by some as justifying the chairman's continued effort to question peer-reviewed NSF grants for the studies that the chairman thinks sounds funny. That said, I want us all to fully appreciate where the pursuit of Neon may lead. Across the government, management fees have always been treated the same as profit. That is, they are the company's money. In that regard, I would note that our staff contacted GAO when we were seeking a witness because GAO is an expert on contract matters. However, staff found that when it came to fees and their uses, GAO had nothing to say because they do not audit fees or profits. So if we're going to move the goal line for Neon and start asking how their fee can be spent and who controls it, we're on a path to tackle the broader question of what everyone else who does business with federal government does with their fees and their profits. For example, major defense contractors do the great majority of their business with the federal government. These same companies spend tens of millions of dollars annually on lobbying. The amounts they spend daily on lobbying dwarf the amount that Neon spent in the entire year. If we are serious about ending such activities, we would have to introduce a bill to put significant restrictions on all companies' federal profits and fees. We would adopt such a law that if we are serious about this issue, but I suspect that our outrage is going to begin and end with this one little environmental nonprofit. I want also to point out the absurdity of being outraged at Neon for using their fee to pay for unallowable cost. This is because under the guidance for management fees, OMB makes clear that by definition, fees can only be used for unallowable cost. Thus, the idea that NSF and Neon colluded to defraud the government into paying for unallowable cost by establishing a fee that would implicate contracting officers all the way back to the Kennedy administration at agencies across the government. Essentially, the NSF Inspector General has made a referral to Justice calling for criminal prosecution of NSF and Neon employees for doing exactly what the law permits them to do. It is hard to see how that represents fraud. The management fee represents less than 0.5% of a 0.5% of the contract costs of the Neon project. The bigger question and bigger money are associated with whether NSF has appropriate policies to estimate project cost, including contingency costs, whether these policies are consistent with OMB guidance. The NSFIG questions the use of contingency and the way the costs estimate on Neon and every other major equipment project at NSF was done. NSF disagrees. As Dr. Buckeyes will testify, they have gone through the extensive audit disposition and appeal process and laid out at NSF. Having adopted reforms, they feel they are fully consistent with OMB's expectations and how to manage risk and estimate cost. A plain reading of OMB's updated regulations unambiguously supports NSF's position. Yet, the ID continues to make every effort to have her views adopted. To put it mildly, this situation is unfortunate, and it is demoralizing to the agency's hardworking staff. But the committee is not equipped to solve any of this today. The National Science Board, the Foundation's Oversight Board, is aware of these issues and has a good understanding of them. I hope that the board will consider a careful review of NSF's practices and policies with respect to large facilities. If the board identifies legitimate facilities management and oversight concerns, I would be happy to join my colleagues in appropriately addressing these concerns. In the meantime, I intend to send a letter myself to GAO asking for a review of how agencies estimate costs for major R&D construction projects and how they set and manage contingency. GAO should look first at how NSF does it and then provide some comparison as to how other agencies do the same things. Perhaps GAO can help settle the impasse at NSF. In closing, I hope we can keep our rhetoric and our actions today measured and based on fact, and be clear that the issues to be considered, if we are serious, go far beyond one small environmental nonprofit use of their fees. And with that, Mr. Chairman, I yield back.
So we are honored to have the presence of the chairman of the full committee with us here today, and so I now recognize chairman of the Science, Space, and Technology Committee, the gentleman from Texas, Mr. Smith, for an opening statement.
Thank you, Mr. Chairman. And Mr. Chairman, also congratulations on having the first hearing of the Oversight Subcommittee of the year, and appreciate your leadership of this subcommittee. Also want to say the ranking member, I'll be happy to join her in the letter that she referred to a couple of minutes ago. Mr. Chairman, this morning's hearing will focus on one of the National Science Foundation's largest major research facility projects, the National Ecological Observatory Network, or NEON project. We're fortunate to have with us today the Chief Operating Officer of the NSF, the Chief Executive Officer of NEON Incorporated, the nonprofit that manages the NEON project, and a representative from the Congressional Research Service. Our witnesses will discuss the process for awarding, managing, and overseeing this $433 million cooperative agreement between the National Science Foundation and NEON. Under this cooperative agreement, NSF has committed to pay up to $433 million to NEON for design, construction, and initial operation of a national network of ecological sensors. The NEON project is the first of its kind, and it's also a huge public investment. To assure taxpayer money is spent appropriately and efficiently as possible, NSF and NEON need to work together closely. As we heard at the first NEON hearing, the Inspector General's independent audit of NEON's cost proposal identified more than $150 million in unsupported or questionable cost. Most or substantially all of these costs might have been resolved by NSF and NEON, but NSF simply went ahead and made the NEON award. A subsequent audit of NEON's accounting system revealed a number of inappropriate NEON expenditures, including lobbying, parties, and travel, all financed by the management fee NSF agreed to pay NEON for ordinary and essential business expenses. These expenditures were brought to our committee's attention and to public attention by a whistleblowing auditor at the Defense Contract Audit Agency, which did both audits for the NSF-IG. The results of the two independent audits and other information show there have been significant lapses in communications and financial controls for the NEON project. In the testimony we will hear today, NEON acknowledges that it has made some serious mistakes. For its part, NSF has already made some internal changes and has issued draft regulations to prevent expenditure of federal funds on expensive parties and other inappropriate activities. The basic responsibility of any government agency is to act in the national interest. I hope we can develop a solution, including the possibility of legislative action, so that this misuse of funds does not happen again. We must remember it is the people's money, not the government's money. This unfortunate situation illustrates the importance of adequate congressional oversight of federal agencies. The NEON's project's problems may never have been brought to light except for the interest and actions our committee has taken. Thank you, Mr. Chairman, and yield back.
Thank you, Mr. Chairman. If there are members who wish to submit additional opening statements, your statements will be added to the record at this point. At this point, I ask unanimous consent that the following documents be entered into the record. We have a list of emails, the letters to Senator Grassley and Paul, as well as the National Science Foundation Business Systems Review. Without objection, we'll have these entered into the record. At this time, I'd like to introduce our witnesses today, and thank you for being here. We appreciate your attendance. Our first witness is Dr. Richard Buckeyes. Did I pronounce that correctly? All right, thank you. Dr. Richard Buckeyes, who is the Chief Operations Officer for the National Science Foundation. Thank you for being here. Our second witness is Dr. James Collins, who is the Chairman of the National Ecological Observatory Network, Incorporated, as well. Thank you for being here. And finally, our final witness is Ms. Kate Manuel, is that right? All right. Who is a legislative attorney with the Congressional Research Service. Again, thank you for being here. Pursuant to committee rules, all witnesses will be sworn in before they testify. And I understand that Ms. Martha Rubenstein, is that correct? Chief Financial Officer for the NSF will be advising Dr. Buckeyes and answering questions on the record. Ms. Rubenstein, please also stand to be sworn in. So if I could have all the witnesses please stand and raise your right hand. Do you solemnly swear or affirm that the testimony that you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Let the record reflect that the witnesses answered in the affirmative. Thank you, and please be seated. In order to allow for discussion, please limit your testimony to 5 minutes. Your entire written statement will be made part of the official record. I now recognize Dr. Buckeyes for 5 minutes to present his testimony.
Mr. Chair, Ranking Member, and members of the Subcommittee, thank you for the opportunity to testify today. My name is Richard Buckeyes. I'm the National Science Foundation's Chief Operating Officer, a position I assumed just in the fall of 2014. As you've just been told, Marty Rubenstein, a colleague, is the Chief Financial Officer at NSF, and she'll be joining me later to answer the questions and answers. The objective of my oral comments are to address your specific questions and to focus on moving forward to improve NSF's processes related to our major research facilities. To make two important context points before I answer the questions you've raised, the National Science Foundation supports fundamental research in the frontiers of knowledge across all fields of science and engineering, primarily through financial assistance awards. That is, our grants and cooperative agreements. The NSF Act of 1950 expressly focuses NSF investments on extramural research. Prohibiting direct operations of laboratories makes us different than some of our sister agencies. The Federal Grant and Cooperative Agreement Act helps determine the mechanisms that NSF uses for its awards. The cooperative agreements are used if substantial involvement is expected by the awarding agency beyond that of a routine monitoring and technical assistance. We use this mechanism to allow the scientific justifications, designs, and specifications to be prepared by the science and engineering community, to permit NSF's involvement in overseeing the scientific progress and investments, and to provide NSF the flexibility to address emerging needs of science and engineering communities. Second, the management of major research facilities such as NEON is of critical importance to the Foundation. As you will hear from Dr. Collins, this is a one-of-a-kind, continental-scale research instrument consisting of geographically distributed, cyber-enabled networks of sensors and biological instruments. NSF relies on outside groups such as NEON Incorporated to build, manage, and operate these unique scientific facilities. Management fees allow these groups to be viable and are an important tool for the stewardship of taxpayers' dollars. Taxpayers, NSF, the scientific community, and the nation would be ill-served if these groups struggle financially or if they fail. NSF acknowledges that some of the activities that Neon Incorporated engaged in using the management fee showed poor judgment, even if they are not in violation of any law or regulation governing the use of these funds. The Foundation has learned a number of lessons about the governance of large facilities and management fees due to this event and has put in place significantly tighter oversight. Now to your questions. First, like all federal agencies, NSF reimburses organizations only for costs incurred under federal awards that are determined to be allowable, allocable, and reasonable under federal cost principles. NSF has controls in place to prevent the reimbursement of costs that are unallowable under federal cost principles. NSF has strengthened requirements set forth by the agency's Large Facilities Manual for prospective large facility awardees to provide adequate documentation for cost estimates and through gateway reviews of these projects. Second, regarding the use of management fees, as you've heard, GAO has concluded that the use of management fees for at least some non-reimbursable expenses incurred by nonprofit organizations represent legitimate needs of the organization and they benefit the U.S. government. Although the payment of management fees has been a long-standing legally permissible practice at NSF and other agencies, guidance on those fees, either government-wide or at NSF, has not been as clear as we need, and enhanced procedures to monitor its use need to be put in place. To this end, I've asked our Chief Financial Officer to work aggressively to complete new policy implementations that will provide specific guidelines on the use of management fees and implement controls to monitor the actual management fee use by awardees to ensure that it is consistent with the intended purposes. These proposed new policies have recently been published in the Federal Register, and NSF is moving forward with implementing their use and evaluating these fee requests. And finally, the contingency cost estimates. NSF is fully compliant with the Office of Management and Budget guidance on the use of contingency fees estimates, including when such estimates may be included in financial assistance awards. This guidance has recently been clarified by OMB and follows industry and government best practices on the construction of large facilities. NSF's strengthened requirements for cost estimates at gateway reviews incorporate these best practices. Mr. Chair, although Neon Incorporated used the management fees in technically permissible under NSF's awards, NSF shares the committee's concerns on the use of management fees. We have used the situation to clarify our policies and procedures in awarding the oversight of such fees. It is only through the strong support of the IG, our Inspector General, and the Congress that complete oversight of taxpayer resources can ultimately be achieved, and we appreciate this support. Again, thank you for the opportunity to testify. The NSF CFO and I look forward to your questions.
Thank you, Mr. Buckeyes. Now recognize Dr. Collins for 5 minutes to present his testimony.
Distinguished Chairwoman Comstock and Chairman Loudermilk, Ranking Member Johnson, and members of the Committee on Science, Space, and Technology, my name is Dr. James Collins. I serve as Chairman of the Board of Directors of NEON, Inc., a 501c3 corporation established to implement NEON, or the National Ecological Observatory Network project. The project is supported by the NSF. From 2005 to 2009, I served as Assistant Director for Biological Sciences at the National Science Foundation. Since 2010, I've had no formal affiliation with the agency. I appreciate the opportunity to come before this committee, which has taken the lead in Congress in ensuring that the United States remains the standard bearer in cutting-edge scientific research. We appreciate very much that this committee has been a strong supporter of the NEON project from its inception. As many of you know, NEON is an advanced research infrastructure for the study and analysis of the biosphere on a regional to continental scale. Living systems are experiencing some of the greatest rates of alteration caused by multiple changes in the environment. These changes affect biodiversity, air quality, water resources, agriculture, and other goods and services that healthy ecosystems deliver to humans. Understanding how these changes impact our natural resources requires a fully integrated, multi-scale research infrastructure to detect, understand, and forecast changes. The data sets collected by NEON will allow us to understand at an unprecedented level of detail the impacts of large-scale environmental changes on our ability to sustainably meet society's food, fiber, energy, and water needs. Moreover, NEON is not only an essential investment for continued U.S. scientific leadership, but it helps fuel our nation's long-term competitiveness and innovation by advancing basic research and applied ecological research. You've asked that I address 3 specific topics in my testimony. The first 2 are, quote, reimbursement for unallowable costs, unquote, and, quote, terms, conditions, and use of management fees. Because I am not a lawyer, I will not attempt to delve deeply into the legal issues relating to unallowable costs and management fees, which are better addressed by the NSF in any event. But let me offer the following. My understanding is that under OMB regulations, unallowable costs are those costs of a business that are not allowed to be charged either as a direct cost or as an indirect cost to a federally funded project. These costs generally include normal business costs, such as fees for termination of contracts, late fees, and general advertising costs. Costs associated with government outreach, alcohol, and social events are also deemed, quote, unallowable, unquote. Unallowable costs cannot be paid with appropriated funds and must be paid by other funds of the organization. NEON has received a management fee from the NSF for the management of the NEON project since 2009. It is our understanding that OMB has long held that fees, in the case of a nonprofit like NEON, or profit, in the case of a private business, are not considered appropriated funds and are outside the scope of OMB Circular A-122 and the Byrd Anti-Lobbying Amendment. NEON has used management fees to cover a variety of costs, including those associated with contract terminations, late fees, and other normal business expenses. NEON has also used management fees to cover costs associated with government outreach, providing amenities including coffee for its employees, and meals and social functions that included the purchase of alcohol. We are aware that NSF is proposing to establish a new policy that would prohibit the use of management fees for these aforementioned categories. Let me say that we understand the NSF's desire to change its policy relative to management fees, and we appreciate the committee's concerns with these types of expenditures. In retrospect, we could have done better when it came to determining how to spend management fees. Moving forward, regardless of what the law allows, NEON will not seek management fees for the expenses that NSF proposes to prohibit, including expenditures for alcoholic beverages and government outreach. Indeed, NEON has already implemented the restrictions that the NSF has proposed. The third issue you have asked me to address is, quote, calculation and use of contingency cost allowances, unquote. NEON is supported by a cost reimbursable assistance award between NSF and NEON Inc., which means that NEON maintains a contingency pool fund. NEON developed a contingency cost proposal consistent with the NSF's Large Facilities Manual. NSF's guidelines include levels of reporting, approval, and review. NSF awarded contingency funds consistent with its proposal. Let me conclude by pledging going forward to redouble our efforts to be good stewards of the taxpayers' funds we receive. We owe as much to the American people and will do what it takes to retain their trust and yours. Thank you, and I welcome your questions.
Thank you, Dr. Collins. Now recognize Ms. Manuel for 5 minutes.
Thank you. Chairman, ranking members, and members of the subcommittees, I'm Kate Manuel, and I'm a legislative attorney with the Congressional Research Service. I'm honored to be testifying before you today on CRS's behalf about certain issues pertaining to the National Science Foundation's use of cooperative agreements. As requested, my testimony provides background information on 3 topics: when agencies may use cooperative agreements and other types of contractual agreement instruments, the allowability of costs under government contracts, and the traditional distinction between fees and costs. First, as to the use of cooperative agreements and other types of instruments. Under federal law, executive agencies generally must use cooperative agreements when their principal purpose is to transfer something of value to a non-federal entity to carry out a public purpose of support or stimulation authorized by federal law, and the agency expects to have substantial involvement with the non-federal entity in carrying out this activity. Grant agreements have the same principal purpose, but must generally be used when the agency doesn't expect to have substantial involvement with the non-federal entity. Procurement contracts, in contrast, generally do not have the principal purpose of transferring something of value, but instead are typically used to acquire property or services for the direct benefit or use of the federal government. All three types of instruments could potentially constitute contracts, as that term is generally understood. The relevant agreement between NSF and NEON appears to have been denominated a cooperative agreement. Second, as to allowability. Allowability is a core concept in compensating the government's partners under legal instruments that do not involve the payment of solely fixed prices or amounts. For a cost to be allowable, it must, among other things, be reasonable or not exceed in its nature or amount that which a reasonably prudent person would incur under the circumstances. It must also be allocable or involve supplies or services that are chargeable or assignable to the federal award or cost objective in accordance with the relative benefits received. In addition, the cost must generally conform to certain limitations or exclusions set forth in the applicable guidelines or regulations or in the agreement itself. As to the three main types of costs discussed in relationship to the NSF-NEON agreement, the relevant guidelines and regulations provide that the cost of alcoholic beverages are unallowable. The cost of entertainment have historically been unallowable, but now may be allowable in certain narrow circumstances. And the cost of specified lobbying activities are unallowable, while other activities are permitted. However, certain provisions of law or policy guidance could be construed to mean that agencies may allow particular costs in individual agreements that would not necessarily be allowable under the standard guidelines or regulations. Third and finally, as to fees. Fees are potentially distinguishable from cost. Fees are arguably best known in the context of federal procurement contracts, since the Federal Acquisition Regulation, or FAR, expressly authorizes the payment of fees as an allowance for profit to contractors working under certain types of contracts. The FAR does not specifically address the management fees reportedly provided for in the NSF-NEON agreement. Similarly, there are no provisions in the relevant OMB circular or regulations or in the NSF's Proposal and Award Policies and Procedures Guide that appear to address management fees in those terms. However, the NSF Guide does provide that payment of fees or profit generally is permissible if expressly authorized by the terms and conditions of the award, and neither it nor the relevant OMB circular or regulations would appear to expressly bar the payment of management fees under cooperative agreements. As a matter of historical practice, some agencies have paid management fees as distinct from cost in the past. However, other agencies have expressly indicated they wouldn't provide management fees, at least to for-profit entities. It should also be noted that the characterization of something as fees or cost in a contract by the parties would not necessarily be dispositive if the overall agreement evidenced a contrary intent. This concludes my oral statement for today. I appreciate the opportunity to have appeared before you and look forward to answering any questions you may have. Thank you.
Again, I thank the witnesses for their testimony, and members are reminded that the committee rules limit questioning to 5 minutes. With that, Chair recognizes myself for 5 minutes for questions. Dr. Buckeyes, as I mentioned in my opening statement, the NSF's letter to Senators Grassley and Paul indicates that 15 of your active awards use management fees. The NSF also notes in that letter that 6 of those awardees, excluding NEON, have received almost $5 million in fees. I appreciate that you acknowledge that there may have been poor judgment used in those fees and that some controls are being put into place. But I'm wondering how much of that $5 million for management fees was spent on liquor, lobbying, and parties and other typically unallowable items.
So we've written to all of the 6 that you've referred to and asked them to report back to us on their use of their management fees. So it's not going to be possible for me to answer that question specifically at this particular time, although we are going to monitor that.
If NEON has been spending taxpayer money under management fees for these type of expenditures, liquor, lobbying, without any apparent knowledge or oversight from NSF, how are we to know that other awardees are not doing the same thing with those? Is that what your report that you're looking to find out with the inquiry that you've done to to these other awardees?
So, as you've just heard from Ms. Manuel, these are perfectly legitimate, I would argue poor judgment, purchases. We are now writing to them all to figure out exactly how they have used it. We just don't have that answer at this point in time.
And I appreciate your forthrightness there. And as you said, there's a lot of times a difference between what is technically legal and what is acceptable or right to do. Do you anticipate are there going to be consequences, or have there been any consequences for those that you are aware of?
Well, because of what you've just been told by Ms. Manuel, since they are legal, the only thing we can do is not provide the next management fee, which is what we did in the case of Neon. Once we found this out, we no longer approved their next request. So that's our technique in order to be able to manage this.
Further, if the NSF's proposed rule, it indicates that NSF is strengthening the controls, as you've mentioned that you're doing. It may be necessary to ensure that the user fees are consistent with those established criteria. This statement presupposes that there were already controls, in fact, in this letter to Senators Grassley and Paul, when discussing management fees. NSF states, given that the fees awarded are discretionary funds, NSF does not require that its awardees report how these monies are expended. Thus, we do not require that the awardees submit an accounting of how they may cover otherwise unallowable costs with the management fee. Since we're talking about taxpayer money that the NSF has awarded, why in the world would you not require awardees to submit an accounting of how they are spending that money?
Well, so your first statement is exactly correct. As we wrote to the senators, we did not ask them to account for that, for all the reasons that we've just discussed, as Ms. Manuel has indicated in the case of such fees. What we do is we ask them at the origination to give us their intent. Okay? In the case of the Neon project, the intent was very explicit. It said meals, it said government outreach, all of which would benefit them in their endeavor. So my point is that we did everything that we could within the restrictions that we had.
With that, and as we've addressed already, that it may have been some poor judgment used, should we be surprised since they did not have to account to you for the monies that were expended? Are we to be surprised that they were used in poor judgment for things such as holiday parties?
So, yeah, specifically, so let's take the government outreach one. In the case of the 2008 management fee description, here's what they said. Neon anticipates the need to provide education to various government organizations as to Neon's mission, strategy, and requirements. That's a perfectly viable thing to use a management fee for, something that we would want them to do. Now, what they did, we thought was in very poor judgment. Okay, it wasn't consistent with what I would have thought that they would have done. But when we gave them the management fee, they gave us an indication of what they were going to do with it, and we assumed that they would.
Well, to follow up on that, so a $25,000 on a Christmas party was outside of what the NSF would have expected Neon to use the money for. Is that what you're saying?
Again, I would say that's poor judgment. And to reiterate what I did say, we have posted in the Federal Register for comment various items that we think should not be included in any future management fees. And we're open to listening to folks to provide us this kind of information so that we are spending the taxpayers' money in the way that we want.
Thank you. Chair now recognizes the gentlelady from Texas, Ms. Johnson.
Thank you very much. Mr. Buckeyes, I have listened to your testimony, and I think you've answered most of the questions. I'm going to ask the question for reiteration. The IG's recommended methods would also be an acceptance within the guidance, I suppose, and so it would seem to me that even though this could be labeled poor judgment, there's nothing about it that's been illegal.
That's a true statement.
And this appears to be a common practice across the government.
I can't comment on that.
Yeah.
I hope not.
But and I know that the IG's recommendations, methods, it would also be in compliance with what you're dealing with now. The IGs seem to differ some, but at the end of the day, who sets the policy in NSF? Is it a director and the board, or is it the inspector general?
So I guess officially it would be the director. Obviously, the way NSF functions, we work very closely with the National Science Board, so I would assume that there's going to be a give and a take to ensure that, but it's the agency that sets down these policies. The IG, as we all know, ensures and checks to ensure that we're all spending taxpayer money the way it should be spent.
Mm-hmm. Can you briefly describe the efforts that NSF has made to accommodate the IG's concerns about the risk and cost estimating and contingency?
Okay, so contingencies can be estimated in a number of different ways. The way we chose to do it is based upon a broadly accepted cost estimating methodology. So this is not money that can be spent any way that they choose. There's a very specific layout of items that can be considered that you can't necessarily predict exactly how it's going to come out. That's the principles that we use. The IG would prefer that we use audits. And the audit that was referred to earlier was done, and we received the information after we had made the award. And that's a very important piece of information. So we made the award, and then the audit tells us that we should have done some reviews otherwise. Our estimating procedures are just different. Okay, I would argue as good as, but different.
Thank you. Now, our research found that the federal government the practice in the federal government goes back to the Bell Report in 1962. And to the degree that OMB even addresses fees or profit, it appears that OMB treats that money as the recipient's funds and not government money.
Correct.
And my time is limited, but I'd like you, Dr. Buckeyes and Dr. Collins, if you would comment on, are you confident that the way the fees were spent by NEON does not represent a violation of law?
Specifically, it does not it is not a violation. Okay. Again, I would use the words poor judgment. Okay, but not a violation.
Thank you, Dr. Collins.
That's correct. It's not a violation of the OMB circular and the guidance that NEON received.
Thank you very much. Thank you, Mr. Chairman. I yield back.
Chair recognizes Chairwoman from Virginia, Ms. Comstock.
Good morning. Thank you, Mr. Chairman. Certainly, we all want to be and are strong advocates for science and scientific research. So the situation today and what we're discussing is really our concern about, not having problems like this, that become public, that are public, and the taxpayers see how their money is spent, and then having that concern that it's not going to the very basic research and the things that we want it to. So I think, and I certainly think my colleagues here, we want to have this discussion so that every dollar we're putting towards this important effort is going to the vital research that we need. So I appreciate, while there may not be legal problems, as you all have indicated, it is poor judgment, and I appreciate that has been recognized. And so I did want to just had some questions here that we wanted to establish for the record, that the Independent Open Secrets website, it said NEON had paid at least $375,000 to registered lobbyists between 2010 and 14. Would you be able to confirm that?
I can't confirm that. But again, for the reasons we said, since it's a management fee, it's permissible.
Okay, and I understand.
But I absolutely agree with everything you just said. Okay, we need to spend taxpayer dollars on science and engineering. That's the goal of the foundation. And so I completely support all of your comments.
Okay, and Dr. Collins?
I'd have to check for the specific number with our financial people, but I know that it's in that area.
Okay, and we can submit for the record, Mr. Chairman, some records from the OpenSecrets.org, which do indicate at $375,000. But if there is a correction that any of the witnesses would like to make, we could also include that in the record. Could you explain the process in terms of hiring the lobbyist and what they were engaged to do?
Well, I was not involved in the hiring of the lobbyist, and as chairman of the board now was not chairman at that particular time. But the engagement had to do, as had been described earlier, with retaining a group of individuals who could work, as far as NEON is concerned, to especially help educate Congress as far as what the NEON project was about, so that you would have the very best information in terms of making the decisions that you needed to make.
I know, and I think that's the concern we have, because I know in instances when I was in the state legislature, we would give money to one body, then they'd want to spend money on lobbyists to come back and lobby us for more money. And so spending taxpayer money to ask us for more taxpayer money, I think, is the frustration here that we have, instead of having it go to the research, because as we're evaluating this and giving the money to NSF, it's because we do value that research. So you can come as an entity, others can come, citizens can come and inform us of this, and that is our responsibility to understand that important thing, rather than have outside lobbyists come and tell us what we're already tasked to do for the taxpayers. So I'm glad that policy will be changed and you understand the poor judgment of that. And I do think that, unfortunately, this happens across the government in a lot of ways. And I know in the case when we were in the state legislature, when that came to us, we stopped that and we said, please just come to us, talk to us about this directly. You know, we're already your advocates, and we want to be your advocates to have more basic research money, but you make our job more difficult when these kind of things happen, and then taxpayers look and say, well, gee, you took our money, but it's now going not to that basic research, but to the lobbyists. So I would appreciate if we could, maybe have any of the letters of engagement or information that you could provide for what they were tasked with, and just sort of what the thinking is there, so that maybe we can look at other areas of research where that kind of thing is going on, where we maybe want to do what you all are doing now, which is putting a stop to that, recognizing that that makes our jobs as advocates more difficult. So I believe I'm running out of time here, Mr. Chairman, so I will yield back my few seconds here.
The gentlelady has yielded back. Chairman Comstock also asked that certain records she referenced be added to the official record, and without objection, I ask unanimous consent that the documents be added to the official record. This time I recognize the gentleman from Florida, Mr. Grayson.
Thank you, Mr. Chairman. Ms. Manuel, stop me if I'm wrong, all right? Among government contracts arrangements like this in general, there are firm fixed price contracts and there are cost reimbursement contracts, correct?
That is one of the ways in the taxonomies in which people talk about contracts, yes.
All right, and among the types of cost reimbursement contracts, there are cost plus fixed fee contracts and cost plus other kinds of fee contracts. Is that correct?
As to procurement contracts, yes.
All right, and the general breakdown, the distinction that's made in that case is between costs and fees of various types. Is that correct?
That is correct.
All right, now costs have to be allowable, allocable, and reasonable, correct?
That is correct.
But not fees, right?
No, if you're talking about the procurement contracts, there specifically the fees have to be earned pursuant to the terms that are set forth in the contract.
All right, so when we're talking about the allowability of costs, we're talking about the allowability of costs, right? Not the allowability of fees. That's a meaningless term, correct?
As a general matter, that would be true. I mean, I can't say that there could never be a contract that purported to blur the two, but in general, that would be the distinction.
All right, but this wasn't one of those blurry contracts, right? This contract provided for costs and for a fee, right?
That is my understanding, yes.
Okay, so we're talking about, at this point, whether $25,000 for a Christmas party, $11,000 for coffee services, $3,000 for dinners, $3,000 for T-shirts and other apparel, and $112,000 for lobbying contracts could be spent as a fee, as part of a fee that the company received, not as part of its allowable costs, correct?
That would appear to be the distinction that was made between there were the things that were cost and were judged in terms of their allowability, and then there was a separate management fee. And insofar as that is a true fee, that would not be subject to the rules regarding the allowability of cost.
All right, so in essence, there are few, if any, restrictions under existing law for what you do with your fee. It's money in your pocket, right?
That would generally be correct, yes.
Okay, and we don't generally dictate to people how they spend their own money, right? It's not a trick question.
Yeah.
It's a pretty basic concept.
We're CRS. I'm trying to think neutral and unbiased how to say this. I think that would generally be the case, yes.
Okay, so we're not going to normally engage in a war on Christmas here and tell people they can't spend their own money on Christmas parties, right?
Insofar as nothing in the contract, it's denominated a fee and nothing in the contract purports to restrict or other law purports to restrict how they use their fee.
Okay, by the way, I'm saying this clip to Bill O'Reilly, just so everybody's aware of those. Listen, when Boeing gets a fee, Boeing gets a fee under many different government contracts and, in fact, earns profits under non-government contracts. Is that correct?
That is correct.
And have you heard the phrase money is fungible? Is that a phrase you've heard before?
Yes.
Okay, so what does that mean exactly, money is fungible?
It's going to mean there that once Boeing has earned its fee, it doesn't matter whether it was, when Boeing's spending it, that it was money that it got from the government or from some other source.
All right,
it's Boeing's money.
So what that means in essence is that since money is fungible, when a company, a human being, any entity receives cash and it's mixed in with other cash, it becomes basically untraceable at that point. Money is money, it's all green, correct?
That is correct.
All right, so when we try to actually trace what happens to fees, we're doing something that's basically difficult, if not impossible, because money is fungible, right?
Insofar as you are talking about a true fee and something like the fees under the procurement contracts, then yes.
All right. The reason why I'm asking these questions and the reason why I'm asking this way is because I don't want this committee to become a scold. I don't want us to be taking it upon ourselves to investigate whether people drank alcohol at specific meals or whether they had a Christmas party. I have a larger, bigger view of science and technology than that. I think of the sky and the stars, and I think of fusion power, and I think of all of the magnificent accomplishments that science has brought to us as a species, as human beings. And I don't want to be dragged down into the point where I'm looking around and saying, I'm shocked that gambling is taking place in this establishment, like in the movie Casablanca. I think we should aim higher than that. Thank you.
Chair now recognizes the gentleman from Ohio, Mr. Johnson.
Thank you, Mr. Chairman, and I thank the panel for being with us today. What we're talking about today is the responsible use of taxpayer dollars. I appreciated my colleague, Mr. Grayson's line of questioning. He said, if I'm correct, he said we can't tell people what to do with their own money. Well, this is not their own money. This is the hard-earned tax dollars of millions of American people that are filling the coffer, and we're talking about accountability on the use of that money, and we're talking about transparency so the American people can see how that money is being used. Dr. Buckeyes, in the NSF's proposed rule, it specifically lists a number of items, including alcohol, non-business travel, non-business meals, luxury or personal items, and lobbying, as example of expenses that do not benefit NSF. Surprisingly, especially given the abuses by Neon, the NSF does not prohibit the use of management fees for these federally unallowable expenses. In your written statement, you indicate that management fees are not to be used for such purposes, but the NSF proposed rule doesn't explicitly prohibit. Why are these expenditures not explicitly prohibited in NSF's proposed rule?
So are you referring to the past or future? So you've just been told that it's perfectly legitimate to expend.
Well, I'm not talking about what's legal. I'm talking about your proposed rule.
Okay, so what we're going forward with is a policy that will ensure that these things are
Does the proposed rule explicitly prohibit the use of those things that you've indicated that are not appropriate?
It's a proposed, remember. We're still taking comment on it.
Does it explicitly prohibit? And do you think it should?
Two different questions. I do think
Let's answer the second one first, because that's an easy one. Do you think it should?
I think it should.
Okay, well, great. Well, then let's discuss accountability for the use of management fees. I have here an email from Timothy P. Cashmere of NSF to Tom Sheldon at Neon on January 8, 2009. And, Mr. Chairman, I would ask that that be entered into the record. Mr. Cashmere says, there is no rule or requirements for drawing down management fees for assistance awards. These are unauditable fees. So do you agree that no one should be surprised that Neon used management fees as it did? By deeming the fees unauditable and informing Neon that there are no rules for their use, did NSF essentially signal Neon that it had carte blanche to use the fees in any way that they desired?
No, that's not true. So they proposed uses for the management fees that did not include the things that you've just referred to. And we provided them management fees to do that.
Okay, well, on what basis?
They went ahead and used it for things that were not in the list.
On what basis do you think then it would be appropriate to conclude that the management fee is unauditable? I mean, is all NSF funding appropriated by Congress?
So I'm not a lawyer. I can't answer that one. Maybe. So I guess the answer is yes, I've been told.
Okay. And is any of the money that's appropriated or that Congress gives to NSF, is any of it not appropriated?
I'm sorry?
My question is, how then, if this is appropriated money, how does it magically turn into non-appropriated money that is not subject to be audited?
Okay, Marty, you're going to have to answer this one.
You can't do that by policy, I don't think.
But this is a fee. This is a management fee, and it has all of the...
But it's appropriated money, correct?
Yes or no? Yes.
Okay, and it's my understanding, Ms. Manuel, isn't all appropriated money from Congress subject to being audited?
I don't know about auditing per se, but I do know with the federal procurement contracts that it is appropriated money that goes out the door in fees, and the general rule there has been that it's the contractor's money once they have earned the fee.
Okay, all right. Dr. Buckeyes, do you agree that regardless of a loophole in the law that the use of taxpayer money on alcohol, and I think you've already said this, entertainment and lobbying is an unreasonable and an inappropriate waste of taxpayer funds?
Our policy going forward, after we receive comment, will hopefully tell have items in it that we would not want our grantees to be doing. And they include the things that you had previously listed.
Dr. Collins, what do you think?
I would make the same point that I do not agree with the way in which the funds were spent at that time. And going forward, we have already put policies in place that are consistent with your point.
Okay. I thank you, gentlemen and ma'am, for answering my questions. Mr. Chairman, I yield back.
The gentleman yields back. The gentleman also has documents that he would like entered into the official record and ask unanimous consent that the documents be entered in official record without objection. They're entered. Now I recognize a gentleman from California, Mr. Barrett.
Thank you, Mr. Chairman. Thank you, Ranking Member, and thank the witnesses for being here. I think we all agree that one of our core jobs and responsibilities as members of Congress is to make sure we're stewards watching the use of taxpayer revenue. So, yeah, I think we agree there. From my perspective, the conversation here is about proper use of management fees versus the program goals of NSF and NEON. And I want to be very clear that, I think most of us on the Science Committee, or many of us in the minority, clearly value the importance of NSF research and clearly understand the importance of programs and projects like NEON, which are incredibly important, particularly as the planet's changing, as biodiversity is changing. We have to be doing this research. I mean, in my home state of California, we're seeing rapid change to the environment. We're seeing record droughts and that are dramatically affecting the biosphere. So, again, this hearing is not about looking at NSF as a program and the value of that science. We're looking at the importance of programs like NEON. So let's be very clear that, from my perspective, these are incredibly important programs. That said, when we, I think in Dr. Buckeyes' opening statements, everyone can acknowledge that there may have been some inappropriate use of management fees. And on a looking forward basis, you look back, you audit, you get a sense of, where may have fees been used inappropriately, not breaking the law, but perhaps lacking good judgment. And in an environment where folks are paying attention to how we're using the taxpayer revenue. Dr. Buckeyes, it's my understanding that, again, looking forward, analyzing how the funds were used in the past, NSF is rewriting the rules, rewriting the policy on what is appropriate use of management fee versus not appropriate use of management fee. Is that correct?
That's absolutely the case. We want to make sure, as I've said a number of times, that the taxpayer dollars are serving this country's interests in science and engineering. And therefore, we believe the management fees are appropriate in order to make these kinds of efforts like NEON functional. But we don't want them to be done or to be expended in a way that doesn't really directly benefit the outcome of the research that we're trying to fund.
Okay. And if I play off of the testimony of my colleague from Florida, Mr. Grayson, NEON's not the only program in the federal government that has appropriated funds that also then have management fees in there. So as we're looking at a single program, is it appropriate? NSF is one of the first agencies that's looking at developing policy on the appropriate use of management fees versus not appropriate.
I can't answer for other agencies. I bet they're looking at them too. But yes, we're looking through all of our large projects like this one in order to make sure that we're all, again, investing in the right way.
Okay. So again, as we redefine what's appropriate use of a fee, let's not limit this look just to a single agency and indict a single program like NEON. As Mr. Grayson pointed out, Boeing, other energy companies, et cetera, get lots of appropriated federal dollars. And I guess, Ms. Manuel, in most of those awards and appropriated funds, is it accurate to say that there are management fees that are part of those?
If you're looking at something like Boeing, those are generally procurement contracts and they're not denominated management fees. They're known as some other type of fee.
Okay, but they're fees.
That is correct.
And there's no federal oversight over how those fees are utilized.
The primary sort of control, if you will, is that the contractor has to have earned the fees pursuant to the terms of the contract.
Okay, but once they earn those fees, they're free to use them however they want.
That is correct.
So, again, what I would suggest is that we don't narrow in and focus in on a single agency, but as we're looking forward to be the best utilization of taxpayer dollars, as NSF is going through their forward-looking proposals on how best to utilize those fees as well as what's appropriate use of fees, there are probably lessons to be learned for other federal agencies and so forth. And again, I applaud the fact that there's acknowledgement that there was poor judgment used and that NSF is taking proactive measures going forward to make sure that, you can't dictate how someone uses their judgment, but we can put in policies and procedures to minimize misuse of funds. So with that, I'll yield back.
The gentleman yields back, and the chair recognizes the gentleman from Florida, Mr. Posey.
Thank you very much, Mr. Chairman. At the usual risk of being vilified as anti-science for any desire whatsoever to have some accountability and some transparency and be a little bit of a watchdog over taxpayers' money, I think it's appalling to many of us that so many employees at the agencies obviously look at the federal budget and taxpayers' money as some kind of big piñata. When you see them spending $150,000 on liquor, parties, lobbyists, I mean, that's the conclusion that my constituents back home would be drawing, and they'd say, what are we doing about that? And so my questions, some of them are, have you recovered any of the money that apparently, obviously, clearly was inappropriately spent?
So let me agree with you as a taxpayer that I want our dollars to benefit this country. But as we've been told, the expenditures and management fees on these kinds of things is perfectly acceptable. I argue poor judgment. I intend to try to make this change going forward. But so far, they're perfectly legal.
And so Neon apparently shamelessly defends them?
As I've said in my testimony, the individuals involved in making these decisions, we could have used better judgment. And going forward from here, we put in place policies that will ensure.
I heard you say that, but
yeah.
if I ripped you off, I would expect that you would say, hey, I want my money back. And I think you've ripped off the National Science Foundation, and I think the honorable thing to do would say, hey, we're going to give you your money back.
Well, to reiterate Dr. Buckeyes' point, and as Mr. Grayson explained, your characterization that Neon had ripped off NSF would not accord with the fact that these fees were provided in a way that were not restricted, and we may disagree with how they were used, but in fact they were used in a way that was consistent with OMB 122.
Well, that's bureaucratic double talk. I don't think we'd be here if it was appropriate behavior of any kind. On the one hand, you're saying it's appropriate. The other hand, you're saying it's inappropriate. We're not going to do it again. I'm just shocked by the answer. So
I don't want to characterize it as appropriate, as I've said. I don't think it was invested in the right way, but it was consistent with the guidance.
If you spent money that the government entrusted to you to do thing A, and you did it on thing B, which was totally a selfish personal indulgence for which it was never intended, should not have been intended, and you admit it should not future ever be intended, don't you think it would be appropriated to pay the money back? I mean, just as a matter of fair play, forget the political double talk, the bureaucratic double speak, just in fairness, in the real world.
Well, as I said, I'm not a lawyer and I don't have the expertise to characterize that, but the way in which
I'm not asking for a legal opinion. I'm just talking, if you were one of my constituents, you'd say, hey, if they spent the money like they weren't authorized to spend it, and it was inappropriate, I mean, who could possibly think the National Science Foundation gave you $150,000 to spend on liquor, parties, and lobbyists? I mean, does anyone in your agency believe that that is the correct use of the money?
At this point, no.
Okay, so don't you think, in all fairness, you just give the money back to begin with?
Well, the funds were invested in a way that were consistent.
That's not invested. Invested on liquor, parties, and lobbyists. And I love your explanation of lobbyists to, what did you say that, to help educate congressmen on the validity of your agency. I think the first thing, if you want Congress to be respectful of your agency, is give the government back the money you cheated them out of.
Well, again, just to repeat, I don't feel that the government was cheated out of the money.
Well, it was of no benefit to the government. We've established that. It was never intended to be spent on liquors, parties, and lobbyists. We've established that. So you got the money. If you planned to do that in the beginning, you took it under false pretenses. If you otherwise, it was just a matter of deception and misuse of money of taxpayers' money that was entrusted to you to do public good.
It would be important to stick with the distinction that Mr. Grayson has made and Ms. Manuel has made in terms of the way in which the fees, management fees, can be used as opposed to appropriated funds. And the management fees came without specific stipulation. Now, going forward, we have put very clear stipulation on the way in which those funds can be used that are absolutely consistent with the spirit that you're trying to bring forth here. And I agree with the spirit that you're bringing forth here.
Well, you don't agree with the spirit I'm bringing forth because you don't advocate repaying the government for the money.
Well, I don't think the agency is in the position to pay back that money because, in fact, the funds have been expensed and they were used in a way that was consistent with the policy at the time.
At the time, because there really was no policy. Is that what you're saying?
There was not the guidance that went down to the specific level that you've been...
And everybody could think you should be able to spend taxpayers' money on liquor, parties, and lobbyists, right? That's a pretty common perception. Is that a common perception in your agency?
It's not a common perception in Neon, and as I said, it's not my perception, and it's not the decision I would have taken, but it was the decision that was taken at the time.
The gentleman's time has expired. The chair now recognizes the gentleman from Virginia, Mr. Byer.
Thank you, Mr. Chairman. Thank you, witnesses. I think it's important to recognize that the worthiness of the Neon Project. And, the climate is changing quickly and dramatically in ways that are affecting and will affect our lives. And the Neon Project offers a capability to give us the data we need to make wise decisions for the American people. So I'm happy that NSF and Neon are already taking concrete steps to implement the audit's findings. But Dr. Collins, we've heard about some of the controversial expenses paid out of Neon's management and fee account. What are some of the less headline-grabbing expenses you charged in the management fee? And do you have other sources of income? For example, if you wanted to pay back the $150,000 for the party and the lobbying, could you? And in paying for the lobbying, what was the purpose of hiring lobbyists? How does that help the mission of Neon and the American public?
Well, as I've said, to take your last question, in terms of the lobbying, it helps the mission as far as providing an explanation for the importance of this sort of investment and this sort of facility. Now, the other kinds of things in which the fees are used would be, for example, on helping to pay for visas for leading scientists who would come to the country and work in this Neon project. The other detail that you raised as far as other sources of funds, there are membership fees that come from universities that are members of the Neon Incorporated, the corporation overseeing the Neon project.
So could you, in theory, use those membership fees from universities to repay the liquor bills for the board meetings?
I'm not a financial expert, and I honestly do not know whether those funds, again, to use a phrase that came up earlier, are completely fungible.
How many employees does Neon have?
350 right now, with a variable group that comes on in the summer of about 100 to 150 temporary employees.
Is it not an important part of management and leadership to create a culture within an organization where people work together, are mutually supportive, or are committed to larger goals?
I would argue that it's extremely important in any group, and especially one as large as Neon.
Do holiday parties sometimes help with that function?
It has been my experience in 25 some odd years of administration that holiday parties can help with that.
And if you didn't pay for the holiday party out of the management fee, how would you pay for it?
Well, there would be no way by which the corporation could pay for it. You would have to do it by contributions from individuals.
If I can address Ms. Manuel for a minute, is there a legal difference in the ability of agencies to set limits on how fees are managed by nonprofits, as opposed to how the profits are spent by other procurement agencies, the Boeing you mentioned earlier? And would we ever have a right to ask how Boeing spent their profits on holiday parties and lobbying?
I think a distinction potentially could be made insofar as you're talking about different types of agreements. And it's very clear with procurement contracts what types of fees are allowed and what has to be done by the contractor to earn them. It's much less clear when you're talking about management fees under a cooperative agreement, what determines the amount of the fee and what makes it payable to the contractor.
Is the profit that a major nonprofit contractor like Boeing makes, is that taxpayer money?
It is.
I yield back.
The gentleman yielded back. Chair now recognizes the gentleman from California, Mr. Knight. The gentleman has no questions. Recognize the gentleman from Michigan, Mr. Mollenauer. No questions. I believe that is the extent of the questions that we have. First, I want to thank the witnesses for their testimony. I think it's been enlightening and will help this committee as we go forward. As I indicated earlier, we have a higher responsibility in the positions that you and I and those that are on this panel have, because we're not just dealing with money. We're dealing with the dollars that taxpayers have sent to us, and we have a higher fiduciary responsibility to use those in a wise and reasonable fashion that actually affects the outcome of the purpose of which the taxpayers have sent us the money. And if there are loopholes, which I think we have identified that there may be some, with expenditures have been identified as poor judgment, $25,000 on holiday parties that was from taxpayers, that I apologize for that. If there are loopholes, which we've identified that there clearly may be loopholes, then it is the requirement of Congress, the people have sent us here, to make sure that those loopholes are closed and that taxpayer monies are spent in a responsible fashion. The record will remain open for 2 weeks for additional comments and written questions from members. But before the members are excused, I have been advised that Mr. Mollenauer does want to ask a question. The gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman. My apologies. I had a budget meeting that I needed to attend, was not able to hear some of the testimony, but I appreciate you being here, and I've been listening to some of the discussion, and I guess my question is for Dr. Buckeyes. Am I pronouncing your name? Okay. There's a NASA and OMB have a policy that indicates that it's always that costs under federal awards must be reasonable, allocable, and allowable. And NASA indicates that paying business expenses, costs that are not reimbursable through a management fee would be circumventing the OMB guidelines and therefore inappropriate. And I just wonder how you would reconcile your position with the position of those agencies.
If so, other agencies do not have the same practices that we do. As I started off in the testimony, there are different attributes of the various agencies. Ours is one where we support extramural research. We don't have physical facilities. So we have reviewed many of the other agencies' practices, and we are going to adjust ours as we go forward. But that doesn't mean that we'll necessarily do exactly as they do, simply because it's a different agency and we have different functions.
Do you think that those policies make sense from their standpoint?
I can imagine in their case where they might come to that conclusion. And we've talked about our posting in the Federal Register, so we're taking input right now. And we're going to close in a couple of weeks so that we can actually then consider all these options.
Do you see any problem with the policies that they have?
For the reasons that we've talked a little bit, management fees do serve a very important function for activities of nonprofits like NEON. And so curtailing, restricting, zeroing will cause a lot of inflexibility that we see could give us some problems, but we do want to take a look at what other people do to ensure that we've got all sides of that.
Thank you, Mr. Chairman. I yield back.
The gentleman in you back. Just want to make sure every member has ample opportunity to ask questions in this first and final round of questioning. Again, I've made a closing statement, but I'll reemphasize how important it is that we be extra cautious and transparent with the expenditures of taxpayer money. I want to again thank the witnesses for your valuable testimony, members of the committee for attending and your questions. And at this point, the witnesses are excused and this meeting is adjourned.